At what age can a child refuse to see a parent? Family disputes over visitation often bring up the question, can a child refuse to see a parent? While these situations are deeply emotional, legal guidance is essential to navigate them. In New York, the answer isn't always straightforward, as the law prioritizes a child's well-being above all else. Legal framework for child visitation in New York. Visitation laws in New York center around the best interests of the child. This principle means that courts carefully evaluate factors such as the child's emotional and physical well-being, their relationship with each parent, and any potential risks. While children can express their preferences, these are only one of many elements considered by the court. Visitation arrangements are typically part of a custody agreement and can be modified if circumstances change. If a child outright refuses to see a parent, the court investigates the reasons behind their resistance. Common causes include emotional distress, allegations of neglect or abuse, or even instances of parental alienation. Ultimately, the court's focus remains on fostering healthy relationships and safeguarding the child's welfare. When can a child refuse to see a parent? In New York, there's no specific age where a child can unilaterally decide not to visit a parent. However, as children mature, their preferences carry more weight in court proceedings. Older children, particularly teenagers, may have greater influence when their reasoning aligns with their best interests. Courts often conduct private interviews, known as in-camera hearings, to understand the child's feelings without external influence. These sessions are designed to protect the child's voice while ensuring that decisions are rooted in their overall well-being. Even so, the final decision rests with the court and isn't solely dictated by the child's wishes. If the refusal stems from legitimate concerns, such as a history of mistreatment, the court may alter visitation arrangements, potentially implementing supervised visits or suspending them entirely. Conversely, if the refusal is linked to manipulation by one parent, the court may address this behavior to restore balance in the child-parent relationship. How does the visitation process work in cases of refusal? When a child resists visitation, the court examines the underlying causes. For younger children, reluctance may be tied to developmental factors, while older children may assert more independence. Regardless of age, the court balances these preferences with evidence to determine what arrangement best serves the child. Parents are legally obligated to comply with visitation orders. Custodial parents must make reasonable efforts to facilitate visits, such as arranging transportation and encouraging the child to attend. Failure to do so can lead to legal consequences, including being held in contempt of court or even modifications to custody. Seeking court intervention early helps ensure that issues are resolved within the legal framework and prioritizes the child's well-being. The process of addressing visitation refusal often requires open communication, mediation, and sometimes counseling. By working with experienced lawyers, families can find solutions that address both legal and emotional complexities while maintaining compliance with court orders. If you're navigating visitation challenges, the law office of Richard Roman Shum, Esq., located at 20 Clinton Street, Apt 5D, New York, 10002, can guide you through the process. Call 646-259-3416 today to schedule a consultation and protect your family's interests.